Let me go back, it was a little more than a decade, to the fall of 1970 when Ray and I started in the U.S. Attorney's Office for the District of Columbia. There were 75 lawyers in the office. Today, I think there are 360. There was no focus on white-collar crime. In fact, it was the U.S. Attorney for whom Ray and I worked, Tom Flannery, who created what he called the Fraud Unit under Seymour Glanzer, and then the Major Crimes Unit under Harold Sullivan, later headed by our good friend and one of the icons of this institute, the late Larry Barcella. When Judge Flannery created the Fraud Unit in 1970, it was the first time in the nation's capital that a United States attorney had ever thought to focus on white-collar crime and political corruption. Gary Naftalis tells me that about that same time, when he became an assistant U.S. attorney in the Southern District of New York, U.S. Attorney Robert Morgenthau had just created the very first securities fraud unit in the country, the Southern District of New York, not until 1970. As the field was evolving in the late 70s, Bob Bennett, John Fetters, and I conceived of and chaired what might be viewed as a great uncle or great aunt to this white-collar crime institute. And Ernestine Murphy was with us, by the way. That institute was called the ABA National Institute on Parallel Grand Jury and Administrative Agency Investigations. The term parallel proceedings was hardly a household phrase in those days, virtually unknown either to corporate lawyers or their clients or to the criminal defense bar. In fact, the subtitle of the institute, Criminal and Civil Implications for Corporations and Their Officers, was an eye-opener to many. People understood that once in a while the SEC and the IRS referred matters to the Justice Department and that they had ways of sharing information with grand juries and with prosecutors. But they were then the outlier agencies. Very few others were doing that sort of thing. The primary statutes available to prosecutors in those days in white-collar cases were mail and wire fraud and conspiracy. Then along came RICO, the Foreign Corrupt Practices Act, the Defense Procurement Fraud Unit at Justice working with the debarment officials at the Defense Department, in very early versions of the voluntary disclosure programs in the Antitrust Division, IRS, and the SEC. That was all. As Ray noted, 30 years ago, this conference, whose anniversary we mark this week, was attended by a small number of lawyers, mostly small firm practitioners who specialized in criminal law. No major law firm had any meaningful white-collar criminal defense capacity. Representing those accused of crimes, even their own corporate clients, was often viewed as beneath the practice of such firms, much like bankruptcy law was in those days. Today, of course, much of the criminal defense bar resides in large law firms, whose practices involve a number of other specialties that provide support and expertise in the kinds of parallel proceedings which now are common. And there are myriad new federal statutes and initiatives in areas such as healthcare fraud, environmental crimes, money laundering, defense contracting, export control, forfeiture statutes, all of which provided the government with weapons that they had not had in earlier years. And what was a nascent voluntary disclosure program 30 years ago in a few agencies now is the norm, and deferred prosecution agreements are the progeny of the trend that encourages, and maybe that's not strong enough a word, that encourages companies to undertake internal investigations and self-report to the government, and then to pay fines and institute compliance and ethics programs in order to extricate themselves from both the criminal and the collateral consequences of their conduct. So it's against this backdrop that I want to discuss a few things with you this morning. There are many things I could have chosen to focus on, but I'll focus on four. One, the increased power of prosecutors in sentencing and plea bargaining. Two, the vanishing jury trial and its impact on criminal defense, the courts, and the bar. Three, electronic discovery and new forms of document dumps. And fourth, probably not a surprise to those who know me, Brady. Without a doubt, the most dramatic change in federal criminal law in the last 3 decades was the enactment by Congress of the Sentencing Reform Act of 1984 and the creation of the United States Sentencing Commission and the Sentencing Guidelines. When many of us were assistant U.S. attorneys in the 70s and early 80s, the government literally had no role to play in sentencing. In most cases, if they attended sentencing proceedings at all, prosecutors would say nothing other than to respond to the court's questions, correct misstatements of fact, and advise the court of a defendant's cooperation. Sentencing generally involved the defendant, defense counsel, and the courts, and judges had complete, unfettered discretion as to the sentence to be imposed. When the Sentencing Reform Act was passed in 1984 and the guidelines were promulgated, judges of that era rebelled. Those in our district remember Harold Green and Lou Oberdorfer and Bill Bryant. Over 200 federal trial judges found the guidelines unconstitutional. The Supreme Court, however, disagreed. Once, years ago, when the guidelines were still mandatory, our late friend, Jerry Pfeffer, invited me to speak at an ABA program on criminal tax fraud prosecutions. Someone in the audience asked what defense lawyers needed to think about in fashioning a persuasive argument for sentencing in a tax fraud or other white-collar case to try to obtain a significantly lower sentence than the one urged by the government. This was at a time when the Controlled Substances Act and the guidelines incorporated a 100-to-1 disparity between crack cocaine and powder cocaine, and as I said, the guidelines were mandatory. And so I said, and some of you won't like this, as they didn't then, what you need to ask yourself is what you could possibly say to a judge who was just forced by the mandatory guidelines to sentence several people that week to 150 months in prison in a crack cocaine case. What you could say that would convince that judge that your client, better educated, employed, intelligent, and sophisticated, who has had every advantage in life, should be given probation or some short period of incarceration. My point being that judges forced to routinely impose unfair, unconscionable sentences on low or mid-level drug dealers found it really difficult to put white-collar defendants on probation and just tell them to hang their heads a little lower the next time they went to the country club. Today, of course, thanks to Booker, the guidelines are no longer mandatory. But the fact that they're now only advisory has really not made as much of a difference in sentencing as we all anticipated. And so why is it that so many judges still adhere to the sentencing ranges in the guidelines when imposing sentence and resist exercising the discretion that we now have? Well, first, most of us really do believe, as Congress did in 1984, at least in the principle that unwarranted disparities in sentencing are fundamentally unfair, and that a defendant's sentence should not be dependent upon which judge's courtroom the defendant happens to be in. Second, it's human nature to find comfort in having some guidance, some delineation of parameters from a group with supposed expertise, the Sentencing Commission. Third, it is easier, particularly for judges with overburdened dockets, to follow the guidelines than to consider the consequences on the real human being standing before them and take the time to tailor an individualized sentence. And fourth, and this is a reality, like it or not, judges know that they are less likely to be reversed or even appealed if they stay within the guidelines. So why take chances? I heard a criminologist once say that the criminal justice system has a hydraulic quality to it. If you squeeze discretion out of one of the players in the system, it necessarily devolves upon another. Now, his examples were Miranda and the Warren Court's Fourth Amendment jurisprudence, which together took a great deal of unguided discretion from the police on the street and shifted it to magistrate judges and district court judges. My predecessors on the bench, the judges who had unfettered sentencing discretion, pointed to the sentencing guidelines as having the same kind of hydraulic effect. Removing the traditional sentencing discretion from the neutral judge results in discretion popping up in a different part of the criminal justice machine, the prosecutor's office. As a result, prosecutors today have immense power in the plea bargaining process and have become vigorous advocates for specific punishments, spending much of their time in the penalty business rather than in the trial business. And Congress has given them a number of potent tools that increases the power of the government in negotiating pleas and in affecting the length of sentences. First, when this institute met 30 years ago, there were 91 statutes on the books that provided for mandatory minimum sentences. Today, there are 194. Judges are bound, as you know, by such statutes if a defendant is convicted of a crime that carries a mandatory minimum, since the statute always trumps the guidelines. Now, there are very few of these statutes that are applicable in white-collar cases, but where they do apply, the prosecutor's discretion to include an offense carrying a mandatory minimum is a powerful weapon for the government and a major incentive to cajole defendants into entering guilty pleas. Attorney General Holder tried to do something about that in the last year of his term. Second, in many white-collar cases, the guideline offense levels are pushed ever upward by the amount of loss or intended loss set forth in the loss amount in Section 2B1.1 of the guidelines and the fine table for organizations in Section 8C 2.4. You know this. In sentencing individuals, the guidelines tell judges to add 8 levels to the base offense level of 6 if the loss amount is as little as $95,000. 16 levels if the loss amount is $1.5 million, and so on and so on. But in truth, the loss amount usually bears little relationship to the true culpability of the defendant and has been shown to have no real deterrent effect. Judge John Newman put it this way, quote, "No thief wakes up and decides to steal $8,000 rather than $12,000. He might decide between robbing a bank and robbing a convenience store, but if he chooses a convenience store, he takes whatever's in the cash register." End quote. And then, of course, that's where Section 3E 1.1 of the guidelines comes in, acceptance of responsibility. It's so important to the decision of a defendant whether to plead guilty because at the high end of the guideline, at the high end of the offense table, often driven dramatically higher because of the loss amount, a 3-level downward adjustment for acceptance of responsibility can eliminate many years from an otherwise applicable guideline sentence. A strong incentive to plead guilty. So then we have even more powerful weapons that Congress has provided, 18 U.S.C. 3553E and Section 5K 1.1. And the analog for organizations is Section 8C 4.1 of the guidelines. Section 3553 and the guidelines give the government absolute, unreviewable discretion to determine whether the information provided by a cooperator constitutes substantial assistance in the investigation or prosecution of another. The court has nothing to say about the substantial assistance determination. No role to play. The prosecutor is the sole gatekeeper, even to the point of being able to eliminate a defendant's exposure to an otherwise applicable statutory mandatory minimum sentence. So this further diminishes the role of judges and provides powerful incentive for potential cooperators and their lawyers to be the first ones in the door of the prosecutor's office. Now, the good news is once the government files its substantial assistance motion, the court has complete discretion as to what sentence to impose, from 1 day to whatever. But again, not all judges use the discretion they've been given. Well, what are the consequences of what I've talked about with respect to sentencing? First, sentences in white-collar cases are considerably higher today than they used to be. You all know that. Available data shows, for example, that the use of probation is down by about 2/3 for fraud offenders and about half for embezzlers and tax evaders, and more white-collar offenders are sentenced to prison time than they used to be. Now, in my view, this is not entirely a bad thing, because I believe that judges in the pre-guidelines era were often too lenient in sentencing defendants for economic crime offenses. Indeed, eliminating the disparity between sentences in white-collar cases and other types of cases was one of the major goals of the Sentencing Reform Act. But to echo my previous point, it still is very troubling in cases when judges impose sentences that are not individually tailored to the particular defendant and fail to carefully consider the arguments you make for mitigation. It is possible to draw a direct line from the phenomenon I've just been discussing to my second theme this morning, the vanishing jury trial. The increase of prosecutorial power and the age of mandatory minimums and guideline sentencing has sown the seeds for the disappearance of the criminal jury trial as we have known it, and perhaps even for the criminal trial lawyer. In 1970, nearly 20% of all criminal defendants charged in the federal courts exercised their constitutional rights to trial. In 1990, it was 15%. By 2000, 6%. And today, it is only 3.1%. The most dramatic drop in the number of trials, an increase in the number of pleas, occurred after the sentencing guidelines and mandatory minimum sentences firmly took hold. The average federal judge in the United States today tries only 17 cases a year, 5 civil and 12 criminal. So perhaps most ironic, a sentencing regime designed to reduce unwarranted disparity in sentencing has created a new disparity between those who plead guilty and those who go to trial. The risk of going to trial is too great. And with the diminishing number of trials, we are at risk of losing both a genuine trial bar and a genuine trial bench. How do we assure that young lawyers still know how to examine and cross-examine witnesses, learned what we learned when we were assistant U.S. attorneys in the 70s, know how to make objections based on a real understanding of the rules of evidence and how they operate in the real world, how to deliver effective opening statements and closing arguments, and separate the wheat from the chaff. And with fewer jury trials, there are not only fewer lawyers with trial experience, but fewer judges who have significant trial experience. What can be done to make sure that those appointed to the bench are not just case managers, emblematic of what is being called the advent of managerial judging, but women and men who understand how to preside over trials because they themselves have had actual experience as real trial lawyers. Now, I bemoan the lack of jury trials, not only because the art of trial advocacy is itself worth preserving, and because skilled, effective, persuasive advocates can make a real difference in a courtroom, but there are institutional reasons we should all be concerned as well. A transparent and open and public court system promotes the legitimacy of the courts, the legitimacy of justice, and the entire criminal justice process. As my friend John Kecker, who's sitting over here, wrote, quote, "Trials let light into the process, helping keep prosecutors honest, cops more honest, judges in check," end quote. With so few trials, though, how do we maintain a credible public face for justice and involve our fellow citizens in the process as jurors? You know, jury trials have always been a vital part of the criminal justice system in this country. Nowhere else in society, but in a robust jury system, do people from different classes and races and occupations and political persuasions and genders and ages, people who've never met and have in common only their membership in the community, all come together to do serious work, sort through the facts and the evidence, and try to reach a just result. And in my experience in criminal cases, Most of the time, they get it right. Okay, a third major change since this institute began 30 years ago is the effect of the digital age upon the prosecution and defense of white-collar criminal cases. Now, I approach this topic with some trepidation. So some of you who have tried cases before me know, since I am admittedly technologically challenged. But I'm comforted by the fact that I'm not alone. There are a great many judges and a great many lawyers, prosecutors, and defense counsel who suffer from the same malady. But we must all confront the new reality. There is no white-collar case today without a significant electronic footprint. Everyone today communicates by email, smartphones, etc., and records are kept in digital form. And the government now responds to discovery requests by producing everything in electronic form. Of course, the shift from physical to electronic discovery has at least the potential to aid defense lawyers in reviewing and evaluating the significance of evidence. But all too often that potential is unrealized when the production of information is best characterized as a data dump, an unorganized, unsearchable mass of electronically stored documents with no index and no roadmap. Such a production dramatically impedes the ability to determine which documents are central to either side's case or even whose files the records came from in some cases. The present criminal discovery rules, unfortunately, do not address this. The present criminal discovery process does not address this. There is no rule that governs the production of electronically stored information, and not even any guidance for judges in the judge's bench book. Now, some judges have gotten creative in the absence of a rule. In one case, a case of mine actually, Magistrate Judge John Facciola decided to look at the Federal Rules of Civil Procedure for guidance. Specifically applying Rule 34, he directed that the documents be produced in a form in which they were ordinarily maintained, or alternatively, that the party producing them organize and label them by category. Magistrate Judge Hugh Scott in the Western District of New York, in another case, United States versus Antonio Briggs, took a similar approach. He concluded that the government was in a much better position than the defense to organize the mass of information and to represent it to defense counsel in a searchable manner. And he ordered the government to do that. So what are judges to do in the absence of a rule? Well, Rule 16 may be helpful in at least one respect. In two decisions of mine, one the same O'Keefe case I just mentioned, and another case where I was discussing with a couple of people last night, United States versus Walter Anderson, I noted that Rule 16A1E provides that upon request, the government must produce to the defendant papers, documents, data, etc. If one, the item is material to preparing the defense, or two, the government intends to use the item in its case in chief, or three, the item was obtained from or belongs to the defendant. Well, prosecutors usually argue, and many district court judges have held, that there's no requirement in the rule that the government identify which of these three categories applies to each item of discovery or to separate them by category. But I exercise my discretion under the rule to order the government in both cases to specifically identify which items in its production the government intended to use in its case in chief, and separately which items were material to preparing the defense. By the way, it led to pleas in both cases. One note of caution, however, don't forget that a request under this subsection of Rule 16 triggers the defendant's reciprocal disclosure obligations. Next, and those who know me knew I'd work this in eventually, what about Brady in a big data case? Can the government simply do a data dump of a terabyte of information and tell defense counsel and the judge that the exculpatory information is in there someplace and the defense can find it? The answer, it depends. The law is clear that if the government is actually aware of favorable information in the massive discovery it is producing, it must specifically identify it as such. As Judge Irene Berger said in the recent Donald Blankenship case in the Southern District of West Virginia, quote, "The United States does not comply with the requirement of Brady by merely including all known Brady material within the 4 million pages of discovery. She therefore required the government to specifically designate, quote, any known Brady material as such and to disclose it." But there's also case law to the effect that where the government does not actually know of Brady material within the massive amounts of information produced, it need not search through it in order to determine whether there is. Perhaps my approach to Rule 16 would help to address this problem as well, at least to a certain extent, because after all, some information, quote, material to preparing a defense under Rule 16 is also exculpatory under Brady. Which leads me to my final area of observation. Brady more generally, and its unresolved and problematic issues well beyond our entry into this new digital age. Let me begin by saying I do not agree with Judge Alex Kozinski that there is, quote, an epidemic of Brady violations abroad in the land, end quote, at least not in the federal system. The Justice Department has attempted in good faith to address the government's Brady and other disclosure obligations through revisions to the U.S. Attorney's Manual, the creation of a criminal discovery coordinator position, annual discovery training for all prosecutors, and multi-day discovery boot camps for new prosecutors. Still, the Department of Justice, under every Attorney General and every Deputy Attorney General, because they usually speak through the deputy on this issue, for at least the last dozen years, has steadfastly resisted the promulgation of a new federal rule on criminal procedure that would clarify the application of Brady at the trial level, has consistently argued against eliminating the materiality requirement when testifying before Congress on proposed legislation, the Murkowski bill after the Ted Stevens trial, and before the Rules Committee. And further, under the Ogden Memorandum, the Department has left key Brady decisions to the individual discretion of each of the 94 separate United States Attorney's offices. Like so many judges, during my first 10 years on the bench, I routinely accepted at face value the government's ritual incantation that prosecutors knew their Brady obligations, were complying with those obligations, and would continue to do so. But I eventually came to the realization, sadly, that there is a fundamental problem with accepting such representations from the government. While most Justice Department lawyers certainly operate in good faith and try to observe the rules, it's been my observation that despite all of the training, not every government prosecutor understands the words favorable or exculpatory the same way. Some give those terms generous interpretations, others narrow ones, and still others, the more self-confident, say, when in doubt, turn it over. The fact is, as you know, prosecutors can become so invested in the cases they bring that they are hardly the best ones to make the decision as to what and how much to disclose. Information that an outside observer would readily label exculpatory or favorable is often seen by the prosecutor as equivocal. A related problem, a serious problem, is that in Brady, the Supreme Court held that the failure of the government to disclose information favorable to the accused violates due process only where the information is, quote, material to either guilt or to punishment. And both the Supreme Court and the courts of appeals have said that material information, in the Brady sense, is information that when there is a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. Now, I've always believed, and it's common sense, that this definition of materiality necessarily is a retrospective test to be applied only after trial is concluded, on a motion for a new trial in the trial court or by the Court of Appeals. The prosecutor, or the trial judge for that matter, should not be looking at the case pre-trial, before the trial even begins, through the end of the telescope that an appellate court uses post-trial. But not all prosecutors, and I'm afraid to say not all trial judges, see things the way I do. They approach Brady on the assumption that the requirement to disclose favorable evidence turns on both favorability and materiality. In United States versus David Safavian, I held that the government must always produce any potentially exculpatory or favorable information without regard to its materiality. I noted that most prosecutors are neither neutral, nor should they be. They are not prescient, and any judgment about whether favorable or arguably favorable information would change the result of the upcoming trial necessarily is speculative on so many matters that simply are unknown and unknowable before the trial even begins. Which government witnesses will be available for a trial? How will they testify at trial? How will they be evaluated by the jury? Which objections to testimony and evidence will the trial judge sustain, and which will the judge overrule? What is the nature of the defense going to be? The prosecutor doesn't know that. What evidence and witnesses will support that defense? What instructions will the court ultimately give? And whether the jury will find guilt on all counts or only on some. I could go on, but you get my point. In my view, there's only one solution. The materiality requirement must be eliminated from the Brady determination at the trial court level, and all potentially favorable information must be disclosed. That always gets applause. The now Deputy Attorney General and I were on a Brady panel at this institute a number of years ago, as was Mary Pat Brown. And I remember very well, after I gave my Safavian speech, that Sally said, Judge, I teach all of my assistants about Safavian. I tell them that's what we should do. I tell them it's best practices. Not the law, but best practices. Well, I've said it's got to be done in my courtroom, as has my colleague Judge Sullivan and a number of others around the country. So, to sum up, or to get close to summing up, Ray, what can judges do to address some of the issues I've been discussing this morning? First, we judges need to be better educated about both electronic discovery and our role in assuring that Brady is complied with. To that end, the Judge's Bench Book in 2013, for the very first time, included a chapter on the duty to disclose favorable information to defendants. It explains Brady and the case law that followed it, the timing of disclosures, the relationship of Brady and Giglio to Jenks and Rule 16. In an appendix, it lists the types of material that may be discoverable or disclosable under Brady, and encourages judges to inquire of prosecutors about the items on this checklist. I plan to suggest to the director of the Federal Judicial Center and the Bench Book Committee that it's time to add a similar section dealing specifically with electronic discovery in criminal cases. And a good place for them to start is the new 2015 Federal Judicial Center Pocket Guide for Electronic Discovery in Criminal Cases. Really good. Which includes, as an appendix, an ESI protocol developed by a joint working group composed of Department of Justice, lawyers, and representatives of federal public defenders' offices. Second, I think judges must play a much more active role in the pretrial management of discovery in criminal cases than we traditionally have. We are accustomed to doing this in civil cases, either ourselves or with the help of magistrate judges or special masters. But in criminal cases, we tend to let counsel work out their discovery problems on their own without that much judicial intervention. And in the case of Brady, we too often accept the government's representation that it knows its Brady obligations and is complying. Judges ought to schedule frequent status conferences in criminal cases, and they ought to have a final pretrial conference, just as we do in civil cases. They should enter standardized discovery and Brady orders in every criminal case. My colleague, Judge Emmett Sullivan, who presided over the Senator Ted Stevens case, has developed a very comprehensive order along these lines and has encouraged other judges to do so. Beyond that, judges should engage in a Brady colloquy with the prosecutor and defense early and often. While modern-era judges have sometimes been criticized on the civil side for spending too much time managing and disposing of cases rather than trying them, maybe on the criminal side, we spend too little time in case management and oversight with respect to discovery and Brady. Third, as I suggested earlier, I think it's time for the Federal Rules of Criminal Procedure to be amended to include a rule specifically addressed to electronic discovery in criminal cases. And I plan to suggest that to the chair of the Criminal Rules Advisory Committee. It is also well past time for a federal criminal rule on Brady, which explicitly eliminates the materiality requirement, makes clear that Brady and Giglio always trump Rule 16 in Jenks, and provides uniformity in the treatment of Brady material by prosecutors and judges nationwide. On that front, I'm not optimistic. Judges Mark Wolf, Emmett Sullivan, and I, among others, have been trying for over a decade to persuade the Criminal Rules Advisory Committee and the Standing Committee on Rules without success. So, in the absence of a federal rule, 27 federal district courts have adopted local rules governing Brady's disclosure, something my court is currently actively considering. 17 other districts have adopted standard orders, and many individual judges have followed Judge Sullivan's lead and entered such orders. So in sum, as I look back on the last 3 decades of white-collar prosecution and defense, 22 of them, hard to believe, as a federal judge, I think my paramount concern is the growing imbalance of power between the prosecution and the defense, and the shifting of discretion from the judicial branch to the executive branch in sentencing. As for judges, I believe that collectively we have neglected our responsibility to seize the opportunity Booker gave us to craft individualized sentences in more cases. We have failed to better manage criminal cases pre-trial, and we have not worked hard enough to find ways somehow to restore, at least to some extent, the important role of the criminal jury trial. But I am optimistic. I sincerely hope that if we work together, the bench, the defense bar, prosecutors, and the rules writers, we can make the kinds of changes I have discussed today to improve a criminal justice system that has served us well for generations. Finally, let me again thank Ray Benoon, Roger Zuckerman, and Sandy Weinberg, and all of those who have made this institute such a formidable force in the white-collar crime world for the last 3 decades, for inviting me to speak today. It has been an honor to address you on this major anniversary. Thank you.